Hi, good morning, everyone, and welcome to today's webinar. My name is Preetha Iyer, and I'll be your moderator. I work in the marketing team here at NatRoad. I'm pleased to introduce today's speaker, Richard Calver. Richard is a compliance and workplace relations advisor, and today he'll be talking about what deductions employers can and can't make from an employee's wages. Before I hand the mic over to Richard, I have a few housekeeping items to cover about this presentation. We request that you put your microphone on mute to avoid any disturbance during the webinar. We'd love to hear from you during today's presentation. If you have a question for our speaker, please feel free to type that in the questions panel of the control panel. You can send in your questions anytime during the presentation. We'll be answering them at the end of the session. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate if you would complete that and provide your feedback. Without further ado, I'd like to kick things off by welcoming Richard Calver. Richard, over to you.
Thanks very much, Preetha. Good morning, everyone. So this is about making deductions from employee wages. So let's just start with the basic concept that taking money out of an employee's pay before it's paid to them is called a deduction. Employers have limited legal power to make deductions from employee wages. And this discussion provides guidance as to when it's legitimate to make a deduction and when it's not. I'm going to speak for about 15 or 20 minutes today, and then I'll take questions. But I must emphasise, because my insurers say so, that what I'm doing today is not giving legal advice. Employers often assume that if an employee owes them money, then the debt can be deducted from the employee's pay or entitlements, or if the employees damaged some of the employer's property, they can also deduct the money from their pay. Both of those propositions are not correct. Unfortunately, what might seem to some employers like a matter of commercial common sense is not consistent with Australian industrial law. That basic proposition in the industrial law is that an employer cannot deduct amounts from employees' pay unless the employer has obtained the employee's consent or express law authority to do so, and the deduction falls within the scope of a permitted deduction under the Fair Work Act. So the principal obligation under the Fair Work Act is for employers to pay their employees amounts payable for the performance of work in full and in money. So there's a limited right not to pay in full and in money. This derives from the 15th century English Truck Acts. Now, truck is not used in that context in the way of a truck that you drive. It's an archaic English term meaning barter. So you can't barter with your employees to give them goods instead of wages, and that was the evil, if you like, that the original English legislation was designed to prevent. That is, wages being paid for in goods, and particularly goods valued by the master, because in those days it was a master and servant relationship. So that kind of protection has been carried forward into the Fair Work Act, and failure to correctly deduct wages is costly. If you're audited by the Fair Work Ombudsman, you could get up to a $63,000 fine if you're a corporation, or a $12,600 fine if you're an individual. And the Fair Work Ombudsman has a target of auditing 5% of businesses. So it's important that you get the deduction of monies from payroll correct. So when can monies be deducted? Well, this slide potentially summarises the provisions of the Fair Work Act. Section 323 of the Fair Work Act requires an employer to pay its employees amounts payable for the performance of work, as I said earlier, in full and in money, except where the making of a deduction from salary is permitted by Section 324. Section 324 says that an employer can make deductions if first the deduction is authorised in writing by the employee, and this is an important test, is principally for their benefit. And the slide uses the example of a salary sacrifice arrangement, which saves employees tax. Then the deduction is permitted if it's authorised by the employee in accordance with an enterprise agreement, a modern award, a contract of employment, or the Fair Work Commission, or it's authorised by another law of the Commonwealth, and that might be, for example, under a court order for the employee to pay child support, where you are authorised to garnish either wages. There is, however, one condition, that the deduction is not unreasonable in the circumstances or directly or indirectly for the benefit of the employer or a related party. So all of those permitted deductions are subject to the test that it's not unreasonable in the circumstances and doesn't directly or indirectly benefit the employer. So it must benefit the employer, and it must be reasonable in the circumstances, and if the employee is under 18 years of age, their parent or guardian must have agreed to the deduction in writing. There are some instances where the Fair Work regulations specifically permit a deduction to be made, and the next slide summarises those examples. So essentially, you're allowed to deduct monies, one, if you've put it in your enterprise agreement or employment contract, and it fits in with these examples under the regulations. That is the cost of items purchased on a corporate credit card for personal use by the employee. Now, that may well constitute misconduct if you haven't authorised that, so be very careful with that proposition, but you might authorise, for example, someone who's in remote or rural Australia to use a corporate credit card for their personal use as long as it's reimbursed. For a company provided mobile phone, you can reconcile at the end of every month or when you get the bill, personal calls, and you can deduct monies from those personal calls from payroll. And then obviously, if the employee has purchased petrol for their private use of a company vehicle, then you can deduct those monies. The records must be very clear there as to what's occurred. We often get questions about whether or not it's permitted to deduct monies where an employee has damaged a vehicle. And the answer to the question is no, it's not permitted. And what we did is we went to our insurers about a question we had from a member, where the member said that the employee had resigned after doing $3,000 worth of damage to a trailer, and they wanted to deduct those monies from the final pay. We said that couldn't occur. They may well have a case to sue the employee, but check the insurance. And we made sure that the insurers answered that question. And the answer we got from the insurer is that in the circumstances I've just outlined, the insurer is covering both the named insurer, that is the business, the proprietary limited company, and also any or all employees of the insured, the company, who are in charge of the vehicles. So the insurance covers that driver. By accepting the claim for damages under the policy, the insurer accepted that the employee is in effect the insured at the time of the damage, and therefore would not look to recover from that employee the $3,000. The fact that the employee subsequently left the employee of the company or the named insured, and even immediately after the incident, didn't alter the situation. So that's the circumstances that say the driver parks the truck and walks away from the employment, and then a number of days later the named insured picks up the truck and discovers some damage, that would be claimable under the policy on the basis of damaged whilst parked, unknown third party. So you wouldn't again deduct those monies from their final pay. There are some circumstances where you can also deduct monies from the pay of an employee where you have met the costs of training, particularly pre-employment training, and that the costs are agreed to by the court or the employee is not being unreasonable. If you want to offer training to an employee that is principally for their benefit, for example, getting a higher class of license, then having a written contractual provision about those training costs is absolutely important, and NatRoad can help you draft a particular provision. The case that I've cited in this particular slide doesn't mean, though, that all recruitment training costs, your training can be clawed back to the employee. It's clearly where they benefit and you don't to the same extent. So this example follows on from the point I made earlier about member feedback when they're interstate, the truck might be damaged or, in this instance, just abandoned. Basically what happened was the employee was interstate, was employed under the long distance award. They missed their slot for delivery. He got very angry and told the employer to put the truck in an anatomically impossible place and resigned. So the truck was locked up with the load on. The employee said they were returning home and would later return the truck's keys, which weren't available. So the employer had the cost of getting another employee to the city where the truck was, rearranging delivery of the load, and incurred quite a lot of costs interstate and getting that other employee there. So in that instance, our advice was not to deduct all of the costs from the employee's pay. Basically, there is a provision in the award where if an employee resigns without giving the required notice, then you can claw back or deduct 1 week's wages from the wages of that employee. In the instance on the screen, the employee had been there more than 12 months, was required to give 2 weeks notice, obviously only gave a matter of hours notice, and so the employer could claw back 1 week's pay. And that provision exists in the award because NatRoad and other employers fought in the commission to keep it in the award. The other question we sometimes get is, what happens if I overpay an employee? And this is a fraught area of the law. You know, you might make a mistake in the payment of wages and overpay. It's a difficult situation. Again, there's no automatic right at law to deduct monies overpaid. The Fair Work Ombudsman says first discuss the issue with the employee. For the deduction to be reasonable in terms of the test I just articulated before, the Fair Work Ombudsman has published some guidelines which say the employee must have a choice about how the money is paid back and how much and over what time frame the payments will be made. So what you need is an agreement, and NatRoad can help you put an agreement like that in place. So where agreement is reached, the employer must record the agreement in writing with the employee's signature. Again, you need that signature to show that it's a legitimate deduction. The agreement has to set out the amount and why the overpayment was made and how repayments will be made, the amount to be deducted from weekly pay and the amount of each repayment. Failure to put that in your payroll records and to show it on the payslip is also a breach of the regulations, and you can get an instant fine for that, about $5,600 if the Fair Work Ombudsman audits you or you're dobbed in by the employee. So part of the reason that the Fair Work Ombudsman has put these guidelines out is that this is a complex area of the law relating to the law of restitution, and we say please seek advice on every occasion about the best way to handle an overpayment. That's because a worker might have done something on the basis of the receipt of the money, thinking it was a bonus or such like, altering their position to their detriment, and therefore having a defence against an action to recover the money. So those circumstances need to be carefully looked at, and we urge you to seek advice if an overpayment has occurred. So just reiterating that, an employer could sue an employee for overpayment made by mistake under the law of restitution, but it's a complex area, and seek advice. And if the employer's changed their position on the basis of receiving that money, changed their position to their detriment, they might have an offence, and we need to look at the circumstances of both the employer and the employee to give you proper advice. All right, so a complicated area of the law, always seek advice before making a deduction from an employee's wages. Make sure that when you engage employees, they have a written contract of employment, and if they are salary sacrificing, that's traced back through the contract of employment. And NatRoad does again offer the service of drafting employment contracts. That's part of our fee-for-service work. Underlining all of this law and the way that both the Fair Work Ombudsman and others will look at it is it's designed to stop employers from making unfair deductions that go right back to the original purpose of the Trucking Acts from the 15th century England, and that the law is viewed through that historical filter. So one way of looking at it is that the nanny state blanket has been spread over employees with harsh consequences for employers who get it wrong. So please come to us for advice, and we're more than prepared to provide that initial advice free of charge. Some of the work will go in our fee-for-service area, but please check in with us. And thank you for listening.